Okay, I'm going to read Part 3, Involuntary Dismissals. Introductory note: if a party's lawyer fails to prosecute an action diligently, the action may be dismissed. Statutes provide for both mandatory and discretionary dismissal. CCP 583.110 through 430 and apply to complaints, cross-complaints, and other initial pleadings. Their purpose is to promote the trial of cases before evidence is lost or witnesses have forgotten facts, and to protect defendants from the annoyance of unmeritorious action remaining undecided for an indefinite period of time. Citing Moran v. Superior Court of 1983, a significant percentage of civil dispositions in the California Superior Courts are dismissals for delay in prosecution. 5.7% of fiscal year 2004 through 5 and 8.6% in 2003 through 2004. See Judicial Council of California in 2006 Court Statistics Report. A dismissal for lack of prosecution before trial is without prejudice. Section 481B3. Because such dismissals are not on the merits, they have no res judicata effect. Wilson v. Biddick, 1965. Consequently, if a cause of action is not barred by the applicable statute of limitations, a party may again litigate it after a dismissal by commencement of a new lawsuit. See Gonzalez v. Bank of America and Nassif v. Municipal Court, 1989. In addition to the statutory diligence requirements, state and local rules provide for involuntary dismissal. The most important are the state and local fast-track rules implementing the Trial Court Delay Reduction Act, which frequently impose shorter time limits than the state statutes and also authorize sanctions for failure to comply. Government Code Section 686.08 and 686.16. CCP 575.1 and 575.2. In addition, a court has inherent authority to dismiss an action for severe misconduct. Lyons v. Wickhorst, 1986. Part 2 is the mandatory dismissal for lack of prosecution. Dismissal is mandatory if a plaintiff fails to meet any of the first three statutory deadlines. 1. Failure to serve an action within 3 years of filing. 583 110 and 583 210. 2. Failure to bring the case to trial within 5 years. CCP 583 310. And 3rd, failure to bring a case to a new trial within 3 years. CCP 583.320. Failure to serve an action within 3 years of filing. Under CCP 583 210A, dismissal is mandatory if the action is not served within the 3 years of filing a complaint. Because return of service is required within 60 days of actual service, the plaintiff has an additional 60 days after the 3-year period to file a proof of service. 583 210B, this provision applies both to named defendants and to fictitious defendants. See Nelson v. A.H. Robbins Co., 1983, Lesko v. Superior Court, 1982. Statutory tolling provisions. Although dismissal for failure to serve within 3 years is mandatory, the plaintiff can avoid dismissal on a proper showing of tolling or excuse, specifically in computing the time in which service must be made. The time during which any of the following conditions existed is excluded. A, the defendant was not amenable to service. B, the prosecution of the action was stayed. C, the parties were litigating the validity of service. Or D, service was impossible, impracticable, or futile due to causes beyond plaintiff's control. CCP 583-240. Under what circumstances is a defendant not amenable to the process of court within the meaning of CCP 583-240? When the defendant is absent from or concealed within the state and his whereabouts unknown. See Watts v. Crawford, 1995. The relevant inquiry is whether the party was subject to being served under applicable constitutional and statutory provisions, not whether the defendant was reasonably available as a practical matter for service of process. Perez v. Smith, 1993. A defendant is amenable to service even though only method of service is by publication. Extensions of the 3-year limit. In addition to these tolling requirement provisions, statutory exceptions to the 3-year requirement apply when the parties extend the period by written stipulation. CCP 583.220, when the parties extend the period by oral stipulation in open court. 583.230, and when the defendant makes a general appearance. 583.220. Finally, estoppel may bar the dismissal where a defendant has induced the plaintiff to delay service. 583.140. Failure to bring the case to trial within 5 years. Under CCP 583.310, dismissal is mandatory if the action is brought to trial within 5 years after it is commenced. The burden is on the plaintiff to ensure that the action is brought to trial within the 5-year period. See Howard v. Thrifty Drug and Discount Stores. As the deadline approaches, the plaintiff must move for preference under CCP's Section 36E or to specifically set the case for trial under Rule 3.1335 of the California Rules of Court. See Wall v. Rodriguez of 1988. Failure to seek a preference may in itself show plaintiff's lack of diligence. See Tejada v. Blas, Westinghouse Electric Corp. v. Superior Court of 1983. The Teja case is 1987. And even where the plaintiff brings such a motion, the court has no mandatory duty to provide a preferential trial date and may decline to do so where the plaintiff has failed to show due diligence in prosecuting the action. See Howard Supra. Motion for preferential trial setting raises essentially the same issues as the motion for discretionary dismissal. The court should consider factors listed in Rule 3.1342E, California Rules of Court. Salas v. Sears, Roebuck and Corp. from 1986. No mandatory duty to set a preferential trial date. Trial court could consider such discretionary factors as the condition of court calendar, dilatory conduct by plaintiff, and prejudice to the defendant of an accelerated trial date. Nye v. 20th Century Insurance Co. of 1990, trial court did not abuse its discretion in refusing to set case for trial before expiration of 5-year period. Plaintiffs who have failed to act diligently will not be allowed to cut in line ahead of diligent litigants. Statutory exceptions to mandatory dismissal. Although the dismissal for failure to bring a case to trial within 5 years is mandatory, a few statutory exceptions do apply. First, the time may be extended by written stipulation or oral stipulation in open court. CCP Section 583.330 A through B. Second, the time will be extended where the court's jurisdiction is suspended, prosecution is stayed. Section 583.340 A through B. Third, the time will be extended where bringing the action to trial was impossible, impractical, or futile. Section 583.340 C. Co. v. City of Los Angeles of 1994. Trial court abused discretion in dismissing action. 5-year statute must be told by aggregate of court-ordered continuances made upon courtroom unavailability. The burden is on the plaintiff to make this showing, which requires proof that the plaintiff has exercised reasonable diligence in prosecuting the case. More on supra. Finally, the time will be extended on a showing of waiver or estoppel, and that cites 583.14. So there is also like a COVID 6-month extension. Now, failure to bring, it's not published in this book, failure to bring the case to new trial within 3 years. Under CCP 583.320, dismissal is mandatory if the plaintiff fails to bring an action to trial within 3 years after a mistrial, hung jury, order for new trial, or appellate remand. See Finney v. District Number 1, Pacific Coast District Association. However, this section does not apply where the initial 5-year period for bringing an action to trial has not yet expired. The plaintiff gets the benefit of the 5-year statutes. That's 583.320d. A plaintiff is entitled to the extension of the 3-year deadline on the same grounds as allowed for an extension of the initial 5-year period. So now we're in Part 3, discretionary dismissals for lack of prosecution. There will be also a Section 4, relief from dismissals. 5, involuntary dismissals under state and local fast-track statutes. Before we get to offer of judgment, so not much longer. Discretionary dismissals for lack of prosecution. Discretionary dismissal is permitted when the plaintiff fails to meet any of one of 3 statutory deadlines. Failure to serve defendant within 2 years, CCP 583.420A1. A2 is the failure to bring the case to trial within 2 years. And Rule 3.1340, California Rules of Court, and failure to bring a case to new trial within 2 years, 583.420A3. C. Lichy v. Federal Land Bank Association of 2002, affirming discretionary dismissal for failure to prosecute 18 days short of the date set for trial. Rule 3.1342E of the California Rules of Court govern the court's exercise of discretion in ordering dismissals on these grounds and requires the court to be guided by the policies favoring the rights of parties to make stipulations and the disposition of actions on their merits. However, before entering a discretionary dismissal, Rule 3.1342E requires a court to consider the entire court file, the availability of parties for service of process, the plaintiff's diligence in effecting service, the extent of settlement discussions, the parties' diligence in discovery and pretrial proceedings, the nature and complexity of the case, the applicable law, the pendency of related litigation, the nature of extensions of time, the condition of the court's calendar, the availability of an earlier trial date, the interests of justice, and any other relevant facts or circumstances. End of Section 3, starting Section 4, relief from dismissals. An amendment of CCP 473 requires the court to vacate a dismissal when an application for relief is made within 6 months of the dismissal and is accompanied by an attorney's affidavit attesting that the dismissal was a result of the attorney's mistake or neglect. By express limitation, this provision of 473 cannot lengthen the mandatory 5-year period for bringing a case to trial in CCP 583.310. See also Bernasconi Commercial Real Estate versus St. Joseph's Regional Healthcare System of 1997. CCP Section 473B does not mandate relief from a dismissal under CCP 583.210 for failure to serve a complaint within 3 years. Should this mandatory 473 relief, based on an attorney's affidavit of neglect, apply to discretionary dismissals, see Peltier versus McLeod River Railroad Co. of 1995, where mandatory relief provision of 473 intended to reach only those dismissals which occur through attorney's failure to oppose a discretionary dismissal motion. Graham v. Beers, 1994, mandatory relief under Section 473 held inapplicable discretionary dismissal statutes. End of Section 4, Part 5 of Subpart C is involuntary dismissals under state and local fast-track rules. The first section, Trial Court Delay Reduction Act, will be followed by the California Government Code for that and case management rules. dismissals, and other fast-track sanctions will be the last part of this section. So, within the Trial Court Delay Reduction Act, the Act, Government Code 68600 through 68,620, the Judicial Council has established the following time goals for disposition of unlimited civil cases assigned to the Case Management Fast Track Program. 75% should be disposed within 12 months of filing, 85% within 18 months, and 100% within 24 months. Rule 3.714B1, California Rules of Court, Standards of Judicial Administration, California Rules of Court, App, Section 2.2 F1, similar rules apply to limited civil cases. 90% should be disposed of within 12 months of filing, 98% within 18 months, and 100% within 24 months. Rule 3.714B2, Standards, Section 2.2 F2. The Trial Court Delay Reduction Act was enacted in 1986 as a pilot project. See Wagner v. Superior Court. Discussing a history of current act, the legislature intended to grant to the project courts under the act wide procedural latitude in developing their own rules and procedures to implement the act in response to the urgent public need to reduce litigation delays and have reached in some counties scandalous proportions. Laborers International Union of North America versus Eldorado Landscape, 1980. After substantial revision in 1988, the legislature of 1990 repealed the original act and enacted the new Trial Court Delay Reduction Act effective January 1, 1991. The new act continued many of the basic policies and goals of the original act, Government Code 68603 and 68607, and applies in all superior courts to all civil actions except juvenile, probate, and domestic relations, and to all limited civil act cases except in small claims and unlawful detainer cases, Government Code 68605.5 and 68620. The new act also continues the emphasis on delay reduction implementation through state and local rules, Government Code 68616, but establishes minimum time periods for certain steps in the litigation process that cannot be shortened by local rule. So now we're reading the California Government Code from 2007, Section 68616, minimum time periods for certain actions. Delay reduction rules shall not require shorter time periods than as follows. A, service of the complaint within 60 days after filing, exceptions for longer periods of time, which I always find funny because it conflicts with 580, CCP 583. So at least that's what I thought. So I'm a little bit mixed up if you have to serve a complaint. Okay, I think you have to serve a complaint within 60 days of the filing, but maybe the proof of service need not be filed to the docket within like 3 years. But why would someone wait? Exceptions for longer periods of time. 1 may be granted as authorized by local rule. That might be 583. And 2 shall be granted. Because it's not local. It's California. Anyway, 2 shall be granted on a showing that service could not reasonably be achieved within the time required with the exercise of due diligence consistent with the amount in controversy. B, service of responsive pleading within 30 days after service of the complaint. The parties may stipulate to an additional 15 days. Exceptions for longer periods of time may be granted as authorized by local rule. C, time for service of notice or other paper under sections 1005 and 1013 of the Code of Civil Procedure, and time to plead after service of summons under section 412.20 of the Code of Civil Procedure shall not be shortened except as provided in those sections. D, within 30 days of service of the responsive pleadings, the parties may, by stipulation filed with the court, agree to a single continuance not to exceed 30 days. It is the intent of the legislature that these stipulations not detract from the efforts of the court to comply with standards of timely disposition. E, no status conference or similar event other than a challenge to the jurisdiction of the court may be required to be conducted sooner than 30 days after service of the first responsive pleading, or no sooner than 30 days after expiration of a stipulated continuance, if any, pursuant to subdivision D. F, Title 4, commencing with section 2016.010 of Part 4 of the Code of Civil Procedure, shall govern discovery except in arbitration proceedings. No case may be referred to arbitration prior to 210 days after filing of the complaint, exclusive of the stipulated period provided for in subdivision 4. No rule adopted pursuant to this article may contravene sections 683 and 689 of the Code of Civil Procedures. Unnamed Doe defendants, this is Part H, shall not be dismissed prior to the conclusion of the introduction of evidence at trial except upon stipulation or motion of the parties, and I, notwithstanding section 170.6 of the Code of Civil Procedure in direct calendar courts, challenges pursuant to that section shall be exercised within 15 days of the party's first appearance. Master calendar courts shall be governed solely by section 170.6 of the Code of Civil Procedure. Case management rules. In practice, the critical rules are the statewide case management rules adopted by the Judicial Council rules 3.700 through 3.750 and apparently 3.1380 through 3.1385 California Rules of Court, as well as the local delay reduction rules adopted by each Superior Court pursuant to the Government Code 686-12 and CCP 575.1. These rules establish time periods that are often dramatically shorter than those set out in the mandatory and discretionary dismissal statutes. For example, 583.210 provides that dismissal is mandatory if an action is not served within 3 years of filing, but under 3.110, a complaint must be served on all named defendants within 60 days after filing unless extended by the court. Rule 3.110B and E Cal Rules of Court. So which one? I'm going to go with the shorter of the two, which is 6 months. So the 3 years is completely mooted. Anyway, in addition to authorizing shorter time limits, the Act reflects a different policy towards stipulation extending time than the dismissal statutes. The dismissal statutes favor the right of parties to make stipulations in their own interest. See CCP 583.130. In contrast, the Act discourages continuances by stipulation of the parties. Government Code 68607G. See also the Rule 3.1332, California Rules of Court, setting forth good cause standards for continuance of trial dates to promote the efficient resolution of litigation. The Act limits the parties to a single continuance not to exceed 30 days. Government Code, Section 686-160. That's so good. I was hoping my trial would get extended quite a bit, but apparently I can't rely on that. The new Act also authorizes the Judicial Council to adopt rules establishing a case differentiation classification system. Government Code 68603E. The implementing rules require a trial court to evaluate each case based on relevant factors and assign each case to a case management plan with a specified case disposition time goal. Rules 3.714 and 3.715 Cal Rules of Court. These rules also authorize a court to exempt certain cases involving exceptional circumstances from case disposition time goals in the interest of justice. Rule 3.714C. Dismissal and other fast-track sanctions. The teeth of the Trial Court Delay Reduction Act are provided by its sanction provisions. Government Code 60608B authorizes a judge to impose a variety of sanctions for failure to comply with fast-track rules, including the power to dismiss actions for straight pleadings if it appears that less severe sanctions would not be effective. See Rule 2.30 California Rules of Court. During the height of reliance on local rules to implement the Act, an issue arose as to whether Government Code 60608B preempted CCP 575.2, which only authorizes the imposition of sanctions that adversely affect the party's cause of action or defense if the failure to comply with local rules is the fault of the party and not the party's attorney. Compare Intel Corp. vs. U.S. Air Inc. of 1991. The trial court properly imposed dismissal of plaintiff's complaint as a sanction for plaintiff counsel's repeated failure to comply with local fast-track rules, with Moyle vs. Lampier 1989, where monetary sanctions affirmed but dismissal action held improper because no showing that client was the cause of counsel's failure to comply with fast-track rules. The Supreme Court subsequently resolved this issue in Garcia vs. McCutcheon of 1997, where it held that the limitations on the power to impose case dispositive sanctions expressed in CCP 572.2 were applicable to violations of all types of local rules, including local fast-track rules designed to implement the mandate of the Trial Court Delay Reduction Act. And that's going to be it for involuntary dismissals. There's one more section in this chapter of offer of judgment. And it's really a read of the California Code of Civil Procedure, Section 998. These are called 998 offers. And then there's a bunch of notes about them. For instance, consequences of failure to obtain a more favorable judgment, effect on award of costs and expert witness expenses, prejudgment interest, what constitutes a more favorable judgment, are court costs added to the verdict, are attorney's fees added to the verdict, revocability of offers of judgment in federal court, before we end Chapter 7 and get to trial and post-trial motions.